Still some people streaming in, but we're going to go ahead and get started just so we stay on time here. I just wanted to welcome everyone to the webinar for taking time out today to be with us. My name is Tom Lindsay. I'm the Senior Legal Counsel at the Center for Democratic and Environmental Rights, and joined today by Mari Margiel. She's our Executive Director at the Center. Again, I just wanted to thank everyone for joining the webinar. It's kind of a deep dive look at the first rights of salmon case brought in a tribal court in the United States. And I wanted to mention that co-sponsoring this webinar with us today is Menīkānaehkem, which is the Menominee grassroots indigenous organization focused on revitalizing the Menominee Nation's communities, including working to protect the rights of nature. Joining us today is the tribal attorney, Jack Fiander, who filed the case that we're talking about today in January in the Sauk-Suiattle Tribal Court as counsel of record in that case. So before we get to kind of the meat of the webinar today, just a couple housekeeping notes. During the presentation, everyone is welcome to submit questions in the chat. So the chat button should be at the bottom of your screen. Chat section will come up on the right-hand side of your screen. We're going to collect those questions and ask them during the Q&A part of the webinar today. So we're going to collect them and then ask them at the end. We're going to keep everyone's microphone muted today just for noise protection of the speakers. And a note that the webinar is being recorded and it's going to be available online as soon as we get the editing on it done. Information on how to keep up to date on this case and on the rights of nature in general, we're going to put that into the chat box, including Facebook, Twitter information, Instagram, and our webpage where you can sign up for the newsletter itself. So without further ado, we're going to break this webinar into a couple different parts. First, I'm going to introduce Jack. Then we're going to talk to Jack for a while about some of the background of the case. And why the case is important, some of the ramifications of supporting the reason for bringing the case as well. Then we're going to do a short PowerPoint, about 10 slides that just gives the framework or skeleton of the lawsuit itself, the claims that have been brought, and what kind of relief is requested by the lawsuit. Then we're going to go back to Jack and talk some more about the case and ramifications and how it can be applied in other situations and circumstances. And then we're going to do a question and answer, questions from the audience as well as questions that we have here. But again, if you have questions, feel free to put them in the chat box and we will circle back around to them when we get to that final section. So without further ado, let me introduce Jack Fiander. Jack is General Counsel for the Sauk-Suiattle Indian Tribe. And this is how the tribe describes itself. The Sauk-Suiattle Indian people have lived under the gaze of White Horse Mountain for many generations as fishermen, gatherers, and hunters in the region of Sauk Prairie and near the present-day towns Darrington, Marble Mount, and Rockport, Washington. We were canoe people, plying the swift waters of the Sauk, the Suiattle, the Stillaguamish, the Cascade, and Skagit Rivers in our river canoes. Though our homelands were in the foothills of the North Cascades, we often traveled downriver to Puget Sound. There we harvested saltwater fish, shellfish, and other foods not available in the mountains. Jack filed the case today as counsel of record in the litigation on the Sauk-Suiattle salmon case and on the tribe's assertion of the rights of salmon. Just wanted to welcome Jack to the webinar today and thank him for taking some time out to talk about this important case. First question to you, Jack, is can you, actually not a question, but can you describe the relationship between the Sauk-Suiattle tribe and salmon? In other words, why is the case so important?
Well, Thomas, as to the Sauk-Suiattle tribe, the Sauk-Suiattle tribe has less than approximately 300 members. It's a small tribe situated on 19 acres. That's the reservation up near the crest of the Cascade Mountains in Washington. It's actually within the National Forest. Nearest town is probably 30 miles away. So because of that, and because of the decline of the timber industry, and, you know, there's no employment there. The tribe has no casino, very little resources. Often we within the tribe kind of joke with one another that most people treat us as though the tribe people, you know, barely have shoes. So the Sauk-Suiattle tribe is dependent on salmon, both, you know, to supplement their diet. Some of what they catch, they can sell over the bank to people, you know, and buy gas for their cars, that type of thing. I guess for the elderly people of the Sauk-Suiattle Indian tribe, the salmon are important to them, even though they are usually of such an age that they are no longer fishermen. Just knowing that there are salmon in the river flowing by gives them peace of mind. Don't know how to describe that. So, except to say that it kind of has a mental health aspect to know that those species they grew up with that are sort of like their neighbors. For the elderly people, just knowing that they're there. And oftentimes they go down and watch them and such as that. And they're particularly important because the Sauk-Suiattle tribe is situated, you know, in the upper reaches of the river. So let's just cast aside that that belief that, you know, the tribal members are responsible for the decline of the fishery. In the area of the Sauk-Suiattle tribe, it's so close to the areas where the adult salmon spawn and lay their eggs that they really can't catch many of them anyway, because on their way there, on their migration from Southeast Alaska all the way back here to spawn and lay their eggs for their future generations, so many of them are caught that by the time they get in the tribe's area, you can only catch a small amount because the Sauk-Suiattle tribe kind of bears the responsibility for that species surviving because they're near the spawning grounds. So they're kind of the guardians of the spawning ground, and they know that if they catch too many, they might not perpetuate. And that's part of the reason for this case is that because of the dams on the Skagit River, perhaps, you know, that's one of many reasons for the decline of salmon. But, you know, having fish passage or other measures at that dam would open up, you know, 90 miles of the Skagit River, almost clear up to and into Canada habitat, you know, and the loss of habitat is one of the main reasons for, you know, the decline of salmon. And because that dam is right above where the Sauk-Suiattle tribal members catch their fish periodically, and you know, the dam's further up, you can't see it. But because our people are visible, you know, you're fishing on the river, you're not out on the ocean where you can't be seen. The tribe gets the blame for the decline of salmon unfairly. And that shouldn't be. And let me explain that. There is one hatchery on this, you know, on a tributary of the Skagit River, where, you know, hatchery fish come from and are raised and released and returned. You know, and there are some wild coho salmon, which are different from the native Chinook salmon that are on the endangered species list. Well, here's how it works. Because when the members of the tribe fish, okay, these runs of different types of salmon are usually running together. They're migrating together. There may be sockeye salmon that originated from a hatchery. There may be coho salmon that aren't endangered, but there are also the native wild Chinook salmon that have been traveling that river since time immemorial. And because they're on the endangered species list, a tribal member where we're at may put their net in the water to harvest from these runs of fish. But if during the course of that, you incidentally catch 1 or 2 or 3 salmon that are on the endangered species list, you have to stop. All fishing stops because that's what's called an incidental take. It's already determined that if you take too many of these native wild salmon, even if it's by accident, you must stop to allow the rest to go upstream to perpetuate.
So Jack, prior to filing this particular lawsuit on the rights of salmon, what steps has the tribe taken to protect salmon populations?
Well, pretty much all we can do where we're at, because like I say, we have no control over offshore ocean fishing. See, these fish migrate in schools up to Southeast Alaska, grow, and on the way back, they're captured by ocean fisheries, by big seine fisheries. On the way back, they've got to make it through Puget Sound, where they're harvested by commercial and sports fisheries. We have no control over that. We're so far upriver that the only steps the Sauk-Suiattle Tribe can take is to not fish, or to limit the number of fish each member can take. And then, like I say, it's not just a commercial impact, that has a downward spiral, within the community that, it takes away their income, it takes away their enjoyment, it takes away something that their ancestors always did, and that they feel they have a right by treaty to engage in, and they can't. Plus, they're stuck with the conservation burden. By the time they get to the Sauk-Suiattle area, the numbers are so small that oftentimes the tribe just says, we're not going to have a fishing season. We need to let these guys who we're obligated to care for pass by us so they can lay their eggs.
Jack, I think a lot of people would be surprised to learn that the tribe's reservation is only 19 acres. Can you talk a little bit about the traditional territory of the Sauk-Suiattle, and for folks that are geographically challenged about Washington State, kind of point out where that was in the state and how large it was?
Well, I couldn't give you an exact number, and you can't really say it was all Sauk-Suiattle Tribe territory, because there were several tribes besides Sauk-Suiattle that signed the same treaty called the Treaty of Point Elliott, in which the tribes relinquished those lands, to allow the settlement of the Pacific Northwest, to allow homestead and private land ownership, and reserved reservations for themselves. And the most valuable thing they did was to reserve their rights to hunt, fish, and gather in those places, because that's what they relied upon for their subsistence and for their diet and for trading. But it was about 11 million acres that was given up during that process.
So before we get to the PowerPoint, do you want to talk a little bit about why the tribe brought this particular case kind of outside the box? Because of course we see a lot of tribes and organizations, nonprofits bringing lawsuits, but using kind of traditional theories of law and remedies. Can you talk about why the tribe did something different than just those traditional remedies.
Well, I guess I would say there's a lot of reasons because traditionally, I guess in mainstream law in the past, tribes relied upon the United States, who also signed the treaties that the tribe signed, to protect the tribal rights. But that policy as to whether the federal administrations support Indian treaties or their responsibility to the tribes can change every time there's a different administration, every time you have a new president. I guess for the Sauk-Suiattle Tribe, there were several reasons they decided that, well, we're an equal partner to that, to the treaty we signed with the United States. We both signed it. So why don't we have as much right to enforce it as the United States does? So I guess that's part of it. The urgency, I think, was because you have native salmon, wild salmon that are on the endangered species list, but also in the next couple of years, there are separate proceedings to relicense the 3 dams on this river before the Federal Energy Regulatory Commission. And that relicensing is for a 50-year period. And unless things change, the wild salmon in this river are going to be extinct in about 10 years or so. So that provided some urgency to the situation, I guess. Also, the tribe, even though small, because it signed a treaty, sort of wants to be treated equally with other governments that have a hand in, salmon perpetuation and regulation. And for example, here in Washington state, there's established, I guess, case law doctrines establishing that the state of Washington has what's called a public trust doctrine to protect the natural resources for its citizens. And because the tribe should be on an equal basis with that. Part of the idea of this case is for the tribe, we want that to have our public trust doctrine to protect these resources for our members recognized as well. So I guess there's a whole mix of reasons, and probably part of it was just the feeling that the tribe has for the salmon, not only the salmon and other species. I hate to sound, corny or metaphysical, but that really is for the Sauk-Suiattle and other tribes, this idea that all things really are connected, and there's not as much distinction between, the humans and other species as we think, and that we do owe a duty to protect them. So, and for my part, in not hesitating to do this is for several reasons. I mean, I don't know if any of the viewers out there are in the law. After a certain age, like myself, people just kind of let you be who you are, and you can tick things off on your bucket list without worry of some kind of opprobrium, because it's a new theory, Thomas, as you know, but is it going to ruin my career? I've got more years behind me than I've got ahead of me, and I think it's important to bring it up. Plus, why I jumped into behind this idea is it always frosted many Indian tribes and tribal attorneys to see the whole, in federal Indian law, there's this concept that went with the establishment of this nation of the doctrine of discovery, that, the people who came here from Great Britain or elsewhere had a right to claim ownership of the country and its resources because they had discovered it. And that idea was, in the Supreme Court decisions, was based on principles of natural law. And in establishing that, the Supreme Court early on in its history even cited the Pope in some of the papal decrees. Well, that always frosted me, and I discussed with the tribal council that you have a creator too. Why is your creator's law any less valuable to bring up as authority for the case than the United States Supreme Court? You have certain unwritten natural laws as well that people within the tribe know, even though they're not unwritten, and you believe they came from your God. So why should that be given any more derogation? Well, why can the Supreme Court say we're following the Pope's decree, or the Treaty of Tordesillas between Spain and Portugal dividing up the world, and you get this half. They have laws that they believe are there from their creator, and they should be just as recognized by businesses that come into their territory.
Great, thanks, Jack. So we're going to come back to you, Jack, after we do kind of dotting the I's and crossing the T's on the lawsuit. So I'm going to go ahead and share the screen on this PowerPoint. People should be seeing it now. And basically, this is just to give a kind of who, what, where, when kind of overview of the case that we're talking about. And then we're going to return back to Jack, ask him some more questions about the case itself and where it's going and why it's important. But this is the rights of salmon in tribal court, and this is the case and the case number for the filing in tribal court. And just a note, up until the time of the wild rice, filing of the wild rice case, the White Earth Band of Ojibwe in Minnesota, which preceded this case, that most of these cases were filed in, to the extent they were filed in state court or federal court. And so this was a change to begin filing these in tribal court, which is an interesting development in these kinds of rights of nature cases. And again, co-sponsors today, CDER, us, and Menīkānaehkem, which is the Menominee tribe's organization, Menominee organization. So the case name is kind of Sulada versus City of Seattle, Sulada being the name of salmon in the Sauk-Suiattle. And this is actually a photograph that Jack provided of the Sauk-Suiattle, some of the members of the Sauk-Suiattle Tribe taken back in 1907. And so the question is, why was the case brought? What is the case about? We've been talking some of that already. These are the parties in the case. The complaint was filed in the tribal court on January 6th of this year, so it's still relatively new. And the plaintiffs are the Sauk-Suiattle Indian Tribe, essentially bringing the case in the name of salmon as guardians or trustees. That's how the case is captioned. And the defendant is the City of Seattle. City of Seattle, of course, owns the company that controls and operates the Skagit River dams. And again, this is the case number for people that want that, lawyers watching or other viewers that want to look it up. That's the tribal court case number. So this is a picture, again, provided by Jack of one of the Skagit River dams. And these are the causes of action in the lawsuit. And the primary cause of action is that the Seattle City Light, which is the company owned by Seattle that operates the dams for hydroelectric power, that the operation of the dams without fish passage, and for folks that don't know much about fish passage, is the ability of salmon, for example, to bypass the dams to actually spawn upriver, that the Skagit River dams don't have fish passage because of the era in which they were built and the intransigence of the operators in trying to achieve that result. But part of the cause of action in the case are that the city's dams impede the salmon from advancing up the Skagit River, that the dams inundated sites of cultural significance to the tribe, and that the resultant loss of spawning and rearing habitat has contributed to this immense, tragic decline of the population of salmon. So Skagit River dams, for folks that don't know much about the dams or their impacts, Seattle City Light, which is owned by the city of Seattle, operates 3 dams on the Skagit River, which provide roughly 20% of the city's electricity. Construction of the dams desecrated indigenous burial grounds and important cultural sites for the tribes. And again, the dams don't provide fish passage for the spawning salmon. Just some statistics, the dams block off nearly 40% of the original river historically used by salmon up until the time of the dam construction. And 3 Skagit watershed salmon species are now listed as threatened, and populations have not only been declining since construction of the dams, but pretty much disappearing almost to a nullity. So this particular case filed in the name of salmon in tribal court is brought on the basis of customary law or unwritten law. In dealing with this rights of nature concept, most places have written laws in place. They've passed ordinances or tribal government laws and then sued on top of those. This one is filed on behalf of unwritten law or customary law of the Sauk-Suiattle Tribe. And again, goes back to salmon being the most important cultural and sacred food, part of the tribe's traditional stories, teachings, lifeways, and spirituality since the earliest times that Jack talked about. And these are some quotes from the complaint, that the complaint is based on the natural laws of the tribe, that tribes are rich in unwritten traditional law and tribal elders as cornerstones of traditional wealth. Again, unwritten law, sometimes called natural law or the creator's law, is found in values, beliefs, practices, customs, traditions, and in the way problems are solved at the tribal level. This is a picture of some Sauk-Suiattle tribal members fishing. And these are some quotes from the lawsuit. As explained, first quote, salmon is sentient like all living creatures, and they are our relations. The tribe has a sacred covenant with Sulata, the water, and all living creatures without which we cannot live. And accordingly, the lawsuit seeks recognition that salmon possess the inherent rights to exist, flourish, regenerate, and evolve, as well as inherent rights to restoration, recovery, and preservation. The concept of salmon having rights that are legally enforceable in court can be traced back to this concept of rights of nature, which has been spreading around the globe faster than I think any of us would have anticipated a number of years ago. But it's the recognition by legislation, so written law, or of jurisprudence, so judge-made law, of the legally enforceable rights of nature, ecosystems, and species. And so the way we kind of look at it is it recognizes civil rights type protections for nature. So nature, specific ecosystems, native species. Folks may have seen the Ecuadorian Constitutional Court decision that came out this past week, which actually recognized individual animals within a species as having certain rights under those rights of nature provisions that were adopted into the Ecuadorian Constitution back in 2008. So a couple other ways of looking at this rights of nature concept of legally enforceable rights for nature and ecosystems kind of transforms nature from being rightless to being rights-bearing, recognizing that nature is a living entity which has inherent rights of its own. And some people trace this rights of nature concept back to the kind of movements that animated the suffragists, the abolitionists, taking things that were seen as property under the law and transforming them into beings or persons, in the case of the suffragists and abolitionists, with certain inherent rights that could be legally enforced. And still others see it as an attempt to strengthen existing environmental laws by heightening the types of protections afforded to nature. And when you do that, there's certain benefits, which include expanded standing for enforcement, because when the ecosystem is the plaintiff, in these cases, that you don't have arguments over who has standing to bring a particular lawsuit to protect a part of nature. New and elevated standards of protection, because of course, generally they rewrite and heighten existing standards of environmental protection. and most of them require restoration as a remedy, which existing environmental laws don't. Sometimes those monies obtained through existing environmental laws and remedies simply go back to the general treasury fund. They're not required to be used to restore an ecosystem back to its pre-damaged state. Tribes have been especially active around rights of nature laws and policies. And this is just a quick list of the tribes that have worked on rights of nature resolutions and laws, including the Ho-Chunk in Wisconsin, the Ponca in Oklahoma, the White Earth Ojibwe, the White Earth Band of Ojibwe in Minnesota, with the webinar we recently did on recognizing the rights of Menīkānaehkem or wild rice and the lawsuit that's emerged from that over a permit issued for the tar sands oil pipeline known as Line 3 for Enbridge. The Menominee tribe in Wisconsin, the Yurok Nation in California, which recognized the rights of the Klamath River under tribal law, and the Nez Perce Nation in Idaho, with a resolution passed by their general council, which recognized the rights of the Snake River. And also, we just learned the Oneida Nation about a year ago passed a resolution dealing with the rights of nature as well. So the concept is expanding within indigenous communities. And to date, over 36 municipal and tribal governments have adopted rights of nature laws across the United States. This is at the municipal and tribal level. And perhaps the two most well-known are the city of Pittsburgh adopted a rights of nature law back in 2010 to protect the 3 rivers within the city of Pittsburgh. And just more recently in 2020, Orange County, Florida, as a ballot initiative passed by 89% of the voters that turned out for that particular election, voted to recognize the Wekiva and Econlockhatchee rivers as having rights within Orange County. County of 1.5 million people, biggest municipality in the United States to pass a rights of nature law to date. These are some of the counts in the Sauk-Suiattle complaint, and this is in addition to the request, of course, for a declaration from the court or ruling from the court that salmon have certain rights and should enjoy certain rights. 4 claims. First claim deals with obstruction of salmon and salmon spawning being a violation of the property rights of the tribe and tribal members and constituting a takings of that property. Count 2, that the dams were constructed without notice or consent of the tribe, constituting a violation of certain other constitutional provisions. Claim 3, that the blockage of water by the dams violates the religious and cultural practices of the tribe. And count 4, that the city's blockage of water by the dams constitutes fraud and infliction of emotional distress on the tribe and tribal members. These are the remedies that are asked for in the complaint. The tribe is seeking a ruling from the tribal court that primarily, of course, salmon possess these inherent rights to exist, flourish, regenerate, and evolve, as well as rights to restoration, recovery, and preservation. Also, that the city's conduct threatens and imperils plaintiffs' rights and significantly impacts their health, welfare, safety, and economic security. And that finally, the tribe possesses a public trust duty to protect salmon, which includes the right to protect access to the waters necessary for salmon to exercise their own rights within tribal territory and beyond. So these are the remedies that are sought by the lawsuit. I think to a lot of people's surprise, not only the wild rice, there are 2 tribal court cases pending around rights of nature as of today. One is that Menīkānaehkem or wild rice case filed by the White Earth Band of Ojibwe in Minnesota against the Line 3 oil pipeline and the water permit issued for that pipeline. This case, of course, dealing with salmon, filed in tribal court as well. But there seems to be a playbook that's emerged between these cases, in that the defendant, which is in the wild rice case, the state of Minnesota and officials within the state of Minnesota, the Department of Natural Resources, and here the defendant is the city of Seattle, that in both cases, the state of Minnesota and the city of Seattle have sued the tribe in federal court to try to strip the tribal court of having jurisdiction to hear the case. So I'm going to say it again, because it comes as a surprise to a lot of folks, I think, that the states or the city as defendants in these cases would go to such lengths to try to strip the tribal court of jurisdiction over these cases. But in both cases, the defendant has run to federal court so U.S. District Court, to try to stop the tribal court from actually reviewing the case and having jurisdiction over the case itself. So in this case, the Salmon case on February 7th, the city of Seattle, contrary to their kind of public relations or publicity about being a green city and about being friendly to indigenous communities and indigenous and sovereignty rights, actually filed a lawsuit in federal district court against the tribal court judge and the clerk of the court in an effort to strip the tribal court of jurisdiction over the case. And so on February 7th, the same day, the city of Seattle filed a motion to speed up. In other words, get the federal district court to interfere sooner to strip the tribal court of jurisdiction. The Sauk-Suiattle Tribe filed a motion to dismiss the case on February 14th. In other words, get it out of U.S. District Court to allow the space for the tribal court to hear the case and, of course, move forward cleared of that interference from the federal district court. And then on February 25th, the tribe responded to that motion for preliminary injunctive relief that was filed by the city of Seattle. But again, the overriding big point here is that whereas the effectiveness or the potential of rights of nature claims has been kind of poo-pooed by a lot of official environmental groups and powers that be in the form of law professors and environmental lawyers have questioned the potential of rights of nature as a claim that certainly these defendants, including in the state of Minnesota, as well as the city of Seattle, have really vouched for its potential efficacy by trying to interfere with tribal court jurisdiction over these cases by running the federal court to try to stop the tribal court from moving forward. So ironically, the folks that should be hearing the message, which is rights of nature can be a very effective legal strategy or theory, aren't moving as quickly with it in some places as the defendants in these cases, backed by industry, who understand perfectly well how efficient or effective rights of nature legal theories could be in court if they are enforced and pressed. So as a final slide, I thought Jack would get a kick out of this, but he sent us some, this was a sign from one of their protests. So Seattle, we want some damn justice. So including that as a final kind of slide here in the PowerPoint. So we'll stop sharing at that point. Come back around to Jack. Jack, anything to add to the PowerPoint? I know there have been some developments since the last slide or the next to last slide was put up. Do you want to catch us up on that? And you're muted, Jack.
Sure, and I'm freezing up from time to time. Again, those of you that are old enough can remember Max Headroom. But hopefully I'm only 2 or 3 seconds, behind everyone in time, and you can hear me. Well, Thomas, as to developments, the briefing is now closed in the federal case. And so if and when the federal judge assigned to the case wants to make a decision, they can, but I don't see how they can, because there's a fairly established doctrine in the federal circuit we're in that the federal court has no jurisdiction to interfere with or stop or review actions of a tribal court until the tribal court proceedings are complete. And at present, hearings in the tribal court were scheduled for today via Zoom, but the day before yesterday, the tribal court judge put out an order saying, I think this is a case of major importance. People might want to attend and observe, and most courts have resumed in-person proceedings. So the case is continued, and I'll set another court date. So that's kind of where it is at. And and I'll shoot updates to Thomas of developments, and maybe he can put them on his website for any of you that want to track the case. I guess I feel the need to sort of jump in and explain something, some inside baseball, which is that Thomas mentioned that these 3 dams on the Skagit River, these hydroelectric generating dams, generate 20% of the electricity for the city of Seattle, which is kind of a mid-sized urban city. So why is that? Well, here's the inside baseball, which is that because in these three large hydroelectric dams, well, one of them is small, don't have the cost of providing fish passage for fish to get around them. They don't have that cost, so it's low cost power, okay? So 80%, and that low cost power is why electricity like Microsoft, like Amazon locate there. They don't have to pay as much for power. So what happens is that the other 80% of that power, because it's low cost to operate, it's low cost power, it's sold outside the state, mainly to put on the grid, sold to California. And then, and that's done at a profit to the utility. And then the revenue from that, Seattle turns around and buys even lower cost power from the federal dams on the Columbia River. And that's what it sells to the people of Seattle. That's kind of inside baseball, Thomas, but it's sort of explained that the tribe also has a companion case that's on appeal in the state courts. It's a Consumer Protection Act case against the city of Seattle for deceptive advertising, because people think they are buying environmentally friendly power. The logos on their trucks, their billboards say we're the greenest utility in the nation. And we think that's false advertising. So we have a whole separate case regarding that, that we had originally filed as a class action on behalf of the electric customers in Seattle, because they need to be told that they're not supporting the environment, they're doing the exact opposite. So I kind of got a little bit off track, but I felt like I had to give the inside baseball of the Emerald City, as it has named itself. It's called virtue signaling, I think.
We love inside baseball. So we have a question from Randy. Randy, I'm going to ask you to unmute and ask your question. Can you do that for us?
Yes, having tuned into a couple of these broadcasts, I'm curious to know how it is that small tribes, no less larger tribes, get recognition. Who do they have to get recognition from? How do they finance creating their own tribal courts? This is a mystery to me.
Yeah.
Oh, okay. Well, I guess in the case of the Sauk-Suiattle Tribe, it's probably easier because they have a tribal smoke shop that sells cigarettes and cigars. Okay, things like that. They provide on the reservation, their own, sewer, water, garbage collection services. They pass that on to the reservation residences, but also the cost isn't that much. Randy, really, you're looking at the whole Sauk-Suiattle Tribe legal department right now, and so it's myself and a part-time legal secretary. And as Thomas said, the seriousness of this is, rather than defending itself, K&L Gates, which has 40 offices around the globe and 2,000 attorneys, is representing the city. So I guess I'm having a great learning experience, because apparently there is a big law playbook. So, so any volunteers out there who want to help, because the playbook is remove it to federal court, dump a truckload of documents on me for discovery, file a motion that you respond to, and then they withdraw it. So they've read your response, and then they file it again, taking your response into consideration. But on the other hand, I mean, just like in the environmental movement or environmental attorneys who have learned how to match the other side step for step just by staying up till midnight sometimes and doing those all-nighters, I think the city has underestimated the passion that the tribe has in going forward. So we do on some all-nighters. We do have a bunch of 2L law students that offer to help. So maybe the cost is less for the Sauk-Suiattle Tribe, even though they have a very small, revenue base. And they do have to fund it find a way to fund it themselves, because, the tribe gets from time to time various different kind of grants and contracts, but those funds carry so many strings attached that you can't use them for litigation, you can't use them for lobbying, blah blah blah. You pretty much have to do it out of your own pocket. So,
Jack, I think part of Randy's question was also about legal authority. In other words, what legal authority is there for the tribe to establish a recognized court? I'm assuming the answer to that is inherent.
Oh, yeah. See, tribes' authority to operate as a government, to have its own court, to have its own laws, those don't derive from like the United States authority. They don't derive from the Constitution. The tribe's authority is from what they call time immemorial rights as a sovereign nation that they've always had, that have never been taken away. It's just that for many tribal people, having gone through these areas of, civilization policies or boarding school policies or something, my friend Thomas Keefe in Spokane, Washington, calls it gets many tribes and tribal people into what they call the abused treaty syndrome, where you're sort of like, let's not even bring it up. We're just going to get drubbed anyway. But for the case of the Sauk-Suiattle, I mean, they're so small and impoverished and beat up on anyway. They're sort of like, how much worse can it get? So, yeah.
Jack, another question that came in deals with, so let's assume that the case moves to the final stage and the Sauk-Suiattle Tribal Court issues a remedy that recognizes Salmon as having certain rights. What are the next steps that you see?
Well, I suppose the next step would be that if the federal court hasn't already stopped the tribal court from acting partway through, it would review that decision and decide whether, as a matter of federal law, the tribe had that authority. I mean, that's called an exhaustion of remedies doctrine. It's a court-created doctrine that, well, the federal court can review tribal court decisions, but only after those remedies are exhausted, kind of patterned after the exhaustion of administrative remedies doctrine. I mean, most tribal advocates think it's a good thing. I mean, I'm kind of an outlier. I think it's one more way of like treating tribes and tribal courts and tribal laws is like we're still in a state of pupillage, and the decisions they need have to be reviewed by another government because they're so incapable of running a court. I think a better doctrine would have been that other courts don't review what a tribal court does. That's an invasion of their sovereignty. And if So the other party, like the city, either has to make a determination of to appear in tribal court and defend itself and be stuck with the decision, or just to take a default and raise the jurisdiction issue like everybody else does at the enforcement, if you try to enforce the judgment against them through their court. But I really don't see the threat. I actually thought the city would either just default and ignore the tribal court, or I unrealistically thought that, well, maybe the city will just join in on this, because we didn't seek any injunctive relief. We just sought a declaratory judgment that the salmon have these rights and the tribe has a trust duty to protect them. It's a declaration. Whether the tribe decides to enforce that, that could result in some prejudice to the city. But in tribal culture, when you kind of expose the falsity of another member of the community, that's sort of called, you're pulling the blanket off them so everybody can see what they really are. And the city is very afraid, I think, of that happening, as evidenced them by hiring an international law firm. And the thing that's troubling is that besides what you call the virtue signaling, and then the city engages in these projects down at the mouth of the river, like planting willow trees along the banks to provide shade for the fish, or buying some land and taking it out of farming and saying, look at how good we're doing, which what it results in is that the city being believed to this good environmental steward, and there you've got these fishermen right up the stream killing all the fish, to where our members regularly, what little time they do get to fish and put a net in the water, most of the time they get hay bales wrapped in barbed wire thrown in upstream so they can't fish. They get their tires slashed just because their method is, because it can't be anybody else, and these guys are the most visible culprits. So let's blame them.
Thank you for that, Jack. We have a question from Blake. Blake, I'm going to ask you to unmute, and then if you can ask your question. Might be on the phone, but the question relates to whether people within Seattle, the Seattle City Council or people within Seattle have taken any steps to actually recognize rights of nature or protect salmon in Seattle.
Well, they have, but not in their own backyard. Seattle has gone on record as calling for the removal of the Snake River dams. They have passed resolutions opposing the Keystone XL pipeline and the Dakota Access pipeline. They based that on the United Nations Declaration of the Rights of Indigenous People. But as to their own utility and its ability to attract big businesses into Seattle, not so much.
So we have another question that came in dealing with if you had to peg the likelihood of the federal court dismissing the city of Seattle's lawsuit trying to strip the tribal court of jurisdiction, what would that be?
Well, I would say 65-35 our way, just because there's such a strongly held doctrine that the federal court must stay its hand, and that's mandatory in the Ninth Circuit until the tribal court is complete. I mean, I would ordinarily say 90%, but as far as staying its hand, there's also part of the exception to this doctrine if the federal judge thinks it's either so plain that the tribe doesn't have this type of jurisdiction, or that it thinks it's just an effort to harass the other party. It can interject itself and halt the tribal court proceedings. And I guess I could see that as a possibility, because this issue has been so important to the tribe. I think that this is like the fourth lawsuit we've had between us and the city, 3 filed by us in federal, state, and tribal court, all on different grounds, and 1 where the city sued our judge and court clerk.
And also to mention that in the White Earth case, the federal district court dismissed out the state of Minnesota's after-district travel jurisdiction, at least at the district court level, and then appealed it up to the 8th Circuit, which is where it sits now. So it's an interesting canoodle that you've put the federal courts in at this point with some of this stuff. So that's good. All right, so we're at the top of the hour, so I'm going to turn it over to Mari to finish us out here.
Well, I want to thank everybody for joining us today, and thank Jack in particular and Thomas for presenting. I want to remind everyone that this has been recorded, and so we're going to make this available on social media and the website and send it to everyone who registered. I also want to thank Menīkānaehkem and I think Guy Ryder, their executive director, has joined us today for his work in helping to sponsor and co-host this event, and the work that he's doing with his own, the Menominee Tribe of Wisconsin, on the rights of nature as well. And to let folks know that we are going to be having more events like this. We're planning one probably for the early part of May, focused on what's been happening in Northern Ireland, with district councils adopting rights of nature resolutions and the steps that are being taken there. So really interesting developments. And just thank everybody. Please stay in touch. Please stay updated. We're putting in resources into the chat for ways that you can join the newsletter and all those things and stay updated, and also to receive notice when the recording of this webinar is available, which should be in the next few days. So thank you so much, Jack. Thank you so much, Thomas. And thanks everyone for joining us.